Guys, one thing that I use Boyd and several other lawyers for is when somebody comes to you with a problem, you can analyze the problem, get an idea what the client's exposure is, and just because somebody has a problem doesn't mean you can't protect them if they have sufficient and substantial assets over and above the worst case scenario. And in this case, someone like Boyd is perfect for analyzing that. And Boyd, you may want to be talking about analyzing cases as part of your discussion, but more important than that, guys, Boyd, if you can wax eloquent on some of the technology you've used when a client's come to you, he's totally underwater, totally starving for money. He feels totally disenfranchised. He's got an aggressive creditor just nailing him, nailing him, nailing him. Talk about some of the techniques that I've seen you use for putting a client back on their feet even though their world has fallen apart around them. And most of these clients don't have asset protection plans until they start renewing their life and putting it together again. I can think of several, Boyd, that you're a maestro at taking someone in trouble and keeping food on their table and their kids in school.
Well, several things you've got to do. If you find yourself in a scenario where the judgment has been taken against you from a private creditor and they are being overly aggressive, your life is going to change. And a lot of times I've had people not like what I've had to tell them because it's foreign to them. But if you are in that situation, it's very difficult to own anything. You're going to have to get into leasing your homes, leasing an apartment, and you're going to have to get used to not owning or collecting or amassing wealth. And in many instances, you're going to have to start fresh. You're going to have to start a new business. I know I can give an example. I've got a client who engages in architecture, and they are from Atlanta and engaged in some projects. Were engaged and hired to work on some projects in Texas, and unfortunately those projects did not go well. Fortunately for my client, when the owner sued the general contractor and the general contractor third-partied in my architecture client, they only brought suit in the name of the business entity. So when you've already got a loss, the most important thing that you've got to consider is fraudulent conveyance. And you cannot, under any circumstances, engage in fraudulent conveyance. The results are worse than if you just let them take what they could get and you just move on and start over, because it draws other people into the suit, your wife, your mother, your father, your brother, your sister, your cousin, your niece, your nephew, your best friend, whoever you've conveyed these assets to now get brought in. And potentially now in some jurisdictions, they're looking at bringing in the professionals, the attorneys, the accountants, the financial advisors that assisted you in hiding the assets from the creditors. So in this particular instance, we knew that after the jury trial and a judgment had gone in against the company, the architectural firm, the company, not the individual, the company. We knew just from the downturn in the economy that the private construction projects aren't coming along in the numbers that they were prior to 2007. They're way down. They're down by about 80% in Georgia. So my client knew that the jobs coming in the future weren't going to be as plentiful or voluminous as they were in the past. So his cash flow was significantly hampered. And the company, having only been working on one or two major projects a year for the past couple of years, did not have a tremendous amount of cash reserves. The E&O carrier had basically, it was a very odd policy in that it only provided $750,000 in coverage, and that included attorney's fees and any monies paid out toward damages to settle the case. They didn't settle the case, and the attorney's fees exceeded $750,000, and when the verdict was rendered, there was no money to pay to satisfy the judgment. Client did not have enough insurance, and he did not have an excess or umbrella policy that would have covered that contingency. So he had some bad business practices that brought about, but I think he's going to be okay, because what we did is we started a new company. We didn't commingle assets, and we didn't convey assets fraudulently. A brand new business with brand new computers, brand new software with receipts purchased from the vendors. New projects coming down the line, going forward under a new company, with plenty of insurance, and with trusts set up to move assets once the company realizes a profit, so that he can move future earnings into vehicles and into venues that are beyond the reach of any potential creditor. His existing company, we'll call it
That's
Company
really
A.
important, guys.
Company A is going to die on the vine, and Company A is going to go through post-judgment discovery. And I can tell you this, post-judgment discovery is a powerful tool, and if you've never been sued and never had a judgment taken against you, when the plaintiff's attorneys or the attorneys that have been hired to collect the debt start sending you packets of interrogatories asking you about your bank accounts, your tax returns, your financial statements, the location of any asset with a value over $500, the identity, the address, the contracts for all realty you've purchased in the past 2, 3, 4, 5, or 10 years, the identity of any realty you own anywhere. When they start asking those questions, you're bound by law to answer them. When you don't answer them, you get 30 days under most jurisdictions to answer those questions, and when you don't, the plaintiff's attorney is going to send you a letter that says, hey, you had 30 days to answer this, you didn't, they're untimely, answer them, or I'll be forced to file a motion to compel. Well, you'll get that letter, or you'll get a certified mail, and it comes back to me unclaimed because you refuse to take the mail because you think, well, if I don't get this, whatever. Well, under Georgia law and a lot of other jurisdictions, when you refuse certified mail, you're deemed to have knowledge of what was in that letter, even though you didn't read it. Always get your certified mail. I should have put that as a bullet point, because what follows next is a motion to compel. And that attorney is going to say, hey, judge, I got a judgment against this guy or this company, and I sent discovery. They were supposed to answer it. It was served on date X. It was due date Y. I reminded them politely with a letter, and they ignored me, so I'm filing a motion to compel. I want, and if it's a company, they'll say, I want an order directing President Bob Smith to answer these interrogatories and document production requests in 10 days and pay our attorney's fees. And the court's going to grant that. When you don't respond at all, the court's going to grant that as a matter of course. It's just a matter of academics. As quick as you can get the pen in the judge's hand, he's going to sign it. So what's going to happen is a sheriff, or again, through that dreaded certified mail, is going to come. And if you don't take the mail, and if you don't do what that order says, I would assume that a lot of people have seen My Cousin Vinny. We laugh when Chamberlain Howell throws Vinny in jail for wearing a leather jacket. But believe me, judges do that. And when they issue an order in a civil court, if you don't do what it says, in Georgia, as in most other jurisdictions, they have the contempt powers of the court. If you disobey a court order, you will go to jail. In Georgia, if I have a judgment against a company that doesn't answer discovery, and I direct it to the discovery and my motion and my order compelling discovery to the president, and he doesn't respond, I can file a motion for contempt and sanctions. And the sheriff is going to come serve the president with that, and then we're going to have a hearing. And in many cases, 90% of the time, no one shows up, and I don't know if I need to start using the word jail versus incarcerate, but I don't know that they understand that I'm asking the judge to throw them in jail. Well, in Georgia, when any sheriff's department or marshal's department executes these civil contempt warrants, they do it on a Thursday or Friday night, and you don't get the post bond because it's not a criminal offense. You stay in jail until the court has a compliance hearing, and I can get to the jail to talk to you, or we're hauled in front of the judge where he can yell at you and chastise you for not answering the discovery. The same thing happens if it's a personal judgment and you just ignore it. You will go to jail. You will go to jail, and you will be put in with the murderers, the rapists, and all the other dregs that you do not want to be around. And you will sit there until the court will hear the case. Usually it's a couple of days, but you will spend the weekend in jail. And it is somewhere you do not want to be. And most of the metro counties here in Atlanta. And so you talk about asset protection, you know, and you want to talk about that, and I mention that, Rob, because it's important. You've got to cut the creditor off at the pass. With Rob, you know, in discussing asset protection in general, I've been able to help a lot of these clients, like my architect client. When we start the new company, it doesn't matter that he started a new company. He started it post-judgment, and he took no assets from the existing company, and he didn't put anything into the new company. He can do that. There's nothing wrong with that. And you can also engage in transactions that would be considered the ordinary and usual course of business. But what you cannot do is take an asset and transfer it to a third party for little or no consideration.
Right, but you started Company B, and by doing that, Company B can make money. Yes, the architect with the individual judgment can't take a large salary because it'll get taken, but that company is not owned by anybody but usually an asset protection trust. It is normally not a debtor to anybody. It normally has no debts at all, and is usually based upon the sweat equity of someone like the architect you described. That is one way to move forward without going bankrupt, guys, even though you have your world falling apart around you. If you can found a company without engaging in a fraudulent conveyance and let it make money and take a small salary from it, that sometimes can buy you the freedom to get yourself out of the mess.
And sometimes, Rob, I'm going to be quite honest, you have to move out of the jurisdiction. You can't stay where they know you are, because you make it easy.
Well, that's important. Now, how far do you have to move? Do you have to go out of the country, or can you just move to Florida?
Oh, no. Move to another state. Sometimes you can just move to another county. It depends on the sophistication of the creditor and their counsel. If you were the CFO of a company and you embezzled a lot of money and PO'd the president, and then he goes and hires DLA Piper in Atlanta, or Alston and Bird, or McKenna Long and Aldridge, or, you know, Greenberg Charig, or Kilpatrick Stockton. I mean, any of these firms, I can tell you right now, if you've got a willing client worth hundreds of millions of dollars willing to pay a $500 to a $700 an hour lawyer to hunt somebody down and take everything they've got, that's your worst nightmare, because they are motivated, and they've got the partner that gets the case, or the associate has forces in the world at his hands to do whatever he needs to do to track down. I've seen these guys come after my clients. They filed 20, 30 garnishments against every single bank in Fulton County. I've seen them garnish every company that they found on the Secretary of State, just spending $50,000 here, $100,000 there, trying to shut them down, block them, catch them, and get something. So if you've got a motivated creditor with an aggressive, accomplished attorney, you got to be 2 steps ahead of them at all times, and you need to be moving before the court gets all the documents and the writs in place to give them the opportunity to come take your assets. So you have to know what you want to do. And I get a lot of times a client will say, well, my daughter's in high school, they don't want to. I said, well, understand the way you used to live is going to change, because you can't do this. They're going to come take your house. What are you going to do when they take it? There's some things that I can't stop, because there's just nothing that legally you can do. If you could manage to sell the house for fair market value before they can lien it and then foreclose on it, then you're a step ahead. But usually real estate transactions take a lot longer than that, so that's usually not a viable option. And you can't just give the house away because it's fraudulent conveyance. So sometimes if you haven't thought through asset protection and done what you've needed to do to get your estate and your business structured and organized in a way that it can sustain the hit of a large judgment, like John's company, you may not have the time and you may not have the ability to save many or a lot of your assets. Now, if there's a situation where you're worth $25 or $30 million and a $2 million judgment goes against you and you don't have asset protection, well, I think in that instance, you can set aside the requisite amount of assets to satisfy the judgment and start planning, you know, your estate and getting your affairs in order to move the majority of your assets outside of the reach of the creditors. I don't think that you're engaging in fraudulent conveyance at that point, because you're keeping assets within the confines and jurisdiction of the jurisdiction where the judgment was entered to satisfy the judgment. It's a very fine line, and you have to be careful. The minute you get the scienter of fraud on you, courts don't like that generally, and you can lose credibility with a judge who might have otherwise sided with you on some issues or matters if you were upfront and don't do anything too aggressive. But in the flip side, if you've got $2 million in assets and a $50 million judgment hits, and everything's in your name, and the judgment's there, and the liens are in place, you're going to lose it. There are some people that are terminal, and there's not really much that can be done. But if you were able to accumulate $2 million, chances are you can probably do it again, hopefully, and it's just going to be a matter of starting over. So there are some instances where you can survive a hit. You just kind of have to take a step to the side, tighten your belt, and move forward correctly and intelligently, so that you don't run afoul of rules involving fraudulent conveyance or the commingling of assets. And you've got to be very clear, and if you're not sure whether something is or isn't a fraudulent conveyance or whether you've commingled assets, then you need to find an attorney and you need to sit down with them, and then you need to go through the transactions that you're concerned about, because they can't be erased. Smaller creditors that get judgments under $100,000, chances are they're not going to pay the bank $2,000, $3,000, $4,000, $5,000, $10,000, $11,000, $12,000, depending on how many records there are for someone to go copy everything to give to an attorney. They're not going to spend money like that. But substantial creditors will do that. I do that. A lot of my clients will pay to do that. We're not going to let you get away. We're going to find and look in every nook and cranny and under every rock to find that one transaction that allows me to get to you. And once I get to you, then I get to anything that you've had. And if it's not protected, and if everything's in your name, then you've made it easy for me, because I can cherry pick what I want at that point, and you can't stop me.
I just hate you, Boyd. You're my worst nightmare.
Well, there's literally probably 100 to 1,000 of me here in the state of Georgia, so there's plenty of us around, and that's the scary part. But by doing what I've done over the past 16 years, I know exactly what you shouldn't do to avoid a garnishment, a levy, or a foreclosure. And it's very difficult, and it's not an easy thing to run a successful business, to have a life, or to be a part of a business, and to come into wealth and assets, and to lose it. I have a lot of clients that came into wealth by benefit of having family members that set up trusts for them, or set up other things, or just gave them money. They came into money or had money, and through a bad business decision or a bad business divorce, lose everything. And they might not necessarily have the ability to go back out and reclaim some of those assets. And certainly, the older you are, it makes it a little more difficult for you to be in John's position and have to try to start over at 59, because I can tell you in this market in Atlanta, pouring footings, foundations, walls, slabs, curbs, gutters, and sidewalks, it's off. If you just look at the Georgia statistics of how many building permits were issued for residential and commercial developments, I mean, it was close to, it was 200,000, close to it. 190 something thousand this year, 180,000. Then it goes down to 16,000. Okay. So Boyd, the majority of these people have gone out of business, and so Boyd, the industry that he knew and understood for so many years isn't really there to provide him with the income at the level he needs to make up for what he lost.
Boyd, so I need you to summarize, and then we're going to answer questions. We've got a little bit over, and if you don't have a summary, you've said a lot of really good stuff, but summarize, right, and then we'll do the questions.
Tony's got it up. Asset protection is a forethought. It's not an afterthought. Your strongest asset protection plans employ business strategies, which we've pretty much spent, business and legal strategies that we spent the majority of the time talking about, financial strategies, your trust, and other things to diversify your portfolio. that are in place well before a suit or claim arises. So if you don't have an asset protection plan, don't wait. And Rob, I think this is something you've always told me, the sooner you do it and the longer that the plan has been in existence, the stronger it's going to be and the harder it's going to be for a creditor to set it aside or bust it.
Old and cold matters. Old and cold, just like your octopus theory or my divide and conquer, those are fundamental rules. Old and cold, just like trust nobody. Old and cold matters. Do it when the financial seas are calm. It's half the price to do it. People like Boyd will be happy you did it because it makes their life much easier. You give him a 5-year-old plan, the statute of limitations on fraudulent conveyancing is gone. He can like run with that. You did the plan 2 weeks before you went to him. He's going to be looking at you sideways.
So this is Tony. Let me get to some of the questions that have come in. Wayne has asked, can the home in the name of a husband and wife be taken in a lawsuit if the wife is not part of the company?
All right, home is in the name of husband and wife, correct?
Yes, correct.
Okay. Can it be taken in a suit involving the company in which the husband owns but not the wife? Is that the question?
Correct.
Do it under Georgia law. Don't bother to worry about the other 49 states.
No,
Most states are very similar to Georgia, guys.
Yeah. Ultimately, at the end of the day, the answer is maybe. Maybe. For instance, if the husband is personally sued and a judgment is taken against him, if the home can be levied upon and it's paid for, if there's a bank mortgage on the property, no, because unless the creditor comes in and pays off the note, the home is pretty much going to be insulated, especially if it's underwater. But if the home is paid for and there's a lot of equity in it, the creditors are going to try to get to it. If the judgment and the suit is against the business only and it never gets to the individual and the creditor can't find something, either a defect in the formation of the company or some transaction that would allow them to pierce the corporate veil, commingling assets or alter ego, to get through to the individual shareholder, to the husband, then no. If the husband is sued, then possibly the home could be taken. It's not a guarantee, but it is possible. And while the suit may not name the husband or the wife in the beginning, it could go that way. I would need more details to answer that question, but yes, the answer is sometimes yes. It's possible.
The answer is probably speak with an expert in your community, a local lawyer who does this.
Yes. Well, that's why I said you need more information, but it is possible. So just speaking, broadly, sometimes yes they can, sometimes no they can't. But just as a follow-up to that, a lot of times if the wife doesn't work, one of the simplest things you can do is title the home in her name. If you are engaged in a business that's high risk or in a business that builds or provides professional services, it's not if, but when you're going to get sued. A lot of times, if the wife doesn't work, it's best to place the home in her name from the get-go. That automatically insulates the home from the creditor. And that's not a bad strategy. Of course, now you run into, if you get a divorce, then it complicates and brings up other issues. But as a general rule, if you have a good marriage and you love your wife and you are engaged in a business that could be considered high risk in your jurisdiction, having the home in your wife's name and having as much out of your name as possible is generally the way to go.
Great, thanks. One of the questions that I've gotten a lot, a topic that I've gotten a lot of questions about during this webinar is about hiding assets. And, some of them I'll try and summarize. If you're self-employed and you submit your records every year to your accountant, then all creditors need to do is ask and demand to see your last 3 years of records. Then your finances are an open book. Another question was, how do attorneys find your assets? And my judgment here is that I think some of our listeners really feel like hiding your assets is the key to this. Could you guys address, the difference between hiding your assets versus separation of ownership?
I don't think you can ever really hide an asset. I mean, the cocaine cowboys did it. They buried cash in the marshes and swamps of the Everglades. That's what I think of when you talk about hiding assets. Or what I deal with a lot here in Georgia is someone will take a helicopter out and put it in a relative's barn, or they'll hide a truck out at their grandmother's. That's what you're doing when you're hiding assets. But if you're paid money and it goes into a bank account and it gets wired out, there's always going to be a paper trail in the digital age here, and it's very difficult to completely erase where your money went or where your assets went, because vehicles have to be registered. Financial transactions over certain amounts have to be reported by the bank to the IRS, and there's always a huge paper trail for this stuff. And so I think hiding assets is more of a misnomer, and I think asset planning would be a better way to describe it. For instance, I know a lot of you familiar with Rob. He really likes the Asset Protection Trust and believes, and I've had clients in Georgia utilize Rob's strategy and follow his asset planning advice, and I've followed up with that here domestically, utilizing the Belizean LLCs and Asset Protection Trust. And you don't have to hide it. The creditor can sit you down and go, where do you bank? In Belize. But don't you bank here? No. Well, do you own a house here? No. Well, how do you get your money? Well, I get a salary from company X. Who owns it? Do you own it? No. So there's always going to be a little pain when there's a judgment entered against you, but it's hard. Hiding assets, it's difficult. I think prior to 2000, prior to 95, 2000, it was probably a lot easier to do, if you want to call it hiding assets. It was much more difficult for people to locate assets, and the reason for that, computers had not manifested themselves and encroached themselves into every aspect of our lives, but the computer is a plethora of information, and there are asset location companies. You want to know how we find your assets? The number one way is we go through and we look at all the public records to determine if anything is titled in your name. The second thing we do is we go to the UCC records and database maintained by the Secretary of State in every superior court in the state. And this is pretty much the same in all the states. Anything that you buy that someone has a security interest in is going to have a UCC1, and it's going to have the VIN number, the make, the model, and the amount listed and filed on a public record. So if you're going to own stuff in your name, there's going to be a public record of it somewhere if you've ever written a check or paid someone. And you can't hide your assets, because when I come to you and I say, produce your bank account, identify all banks you've had an account with over the past 10 years. Produce the bank statements, records, canceled checks for every account you've maintained for the past 5 years. You know, you gotta fork that stuff over. You can't hide it once it gets to that point. The only thing you can do at that point, you're not hiding your assets. You got to hide yourself. You've got to make yourself unavailable for service. You can't own a home in your name. You can't sit at home. You're going to be in fear every time the doorbell rings, because you're going to look and see, and if it's a man wearing a badge with a clipboard, the sheriff is there to serve you with something. And if it's a stranger holding a manila envelope, then you know he's a process server there to give you something. So you can't hide your assets. You can hide yourself, but if you can't hide yourself, you can't hide your assets. I don't know if that makes sense, but if they can find you, and if they can get documentation or paperwork in your hands, or if you're represented by an attorney and they get that paperwork in your attorney's hands, it's going to be very difficult at some point not to have to fork over that information, unless you find yourself on the other side of a contempt action in front of a judge. So it's very difficult to hide the assets. It costs money to find them. It's not easy. Facebook, Twitter, everything, it can be used to locate and find assets. But the public records and the public databases, all your real estate holdings, everything, the Secretary of State in many instances will identify you and show a potential creditor every business entity that you have ever owned or ever had an interest in. And then they start and they go and they start working down the line. They can depose your wife. They can depose your brother, your sister, your mother, your father. Rule 69 in most jurisdictions, and the federal court says you can engage in post-judgment discovery to identify and locate the nature and extent of a debtor's assets by using whatever the local jurisdiction says you can do. So in Georgia, Rule 69 says we can serve interrogatories, which are written questions. We can serve document production requests, and we can take depositions. So I can subpoena third parties to a deposition. So if my client is aggressive, I can start shooting out subpoenas to family members. There are a number, through the advent of technology and software, programs that you can find to locate people and their assets. And someone like me, I'm a prime candidate for that. God help me, I'll knock on wood, but if I ever get sued and a judgment gets against me, everything I own is right there at a creditor's fingertips. I own a home. I have interest in companies. I've got, a family farm, I've got cars. It's not going to be hard to find my assets. So
And now you have a recording of all of it.
I do, but it's a matter of public record.
They'll introduce this one too.
Yeah, it's all there. So I'm very easy to find, as are most Americans. But the problem is I'm not worth $100 million. And I'm not engaging in business transactions and lines of business selling medical equipment or, selling pharmaceutical drugs or healthcare supplements. I'm not advertising on the Internet. Well, kind of I am, but not like a lot of companies. And I'm not engaging in commercial trade transactions that would constitute interstate commerce that would draw the ire of the IRS. And I've got a lot of insurance. So you have to consider what you're doing. And I have work to do on my own estate, and I will be doing that. But hiding assets, very difficult to do in this day and time, unless you expatriate everything and get it out of the country. But when you do that, there's the convenience factor. It's not readily available at your fingertips, depending on where you put it. And once you get it out of the country, you may have a hard time getting it back in. And so hiding assets in the U.S. is difficult to do. But you want to minimize, the way you do that is minimizing your electronic footprint. But that comes back in to forming and organizing businesses correctly. If your accountant says, oh, you should be a sub-S in Georgia, well, the Georgia Secretary of State makes you list the CEO, the CFO, and the Secretary. It's a requirement. Those people are identified, and their names are right there for Google to find. If you know how to look up stuff on a Secretary of State's website and do a business search, you're going to find them. You can search their names. However, if you're a Delaware LLC, none of that's there. Delaware just says the name of the company is 123 LLC. My registered agent is Corporate Service Corporation Company, 131 Willington Street, Delaware. And that's all they'll find when they look there. It's not going to tell them who owns it. It's not even going to tell them where the business is principally located. You could run a Delaware LLC out of any of the 50 states if you wanted to. And even if you formed the Delaware company and you domesticated in Georgia or Alabama or any other state, most states, not all, but most, they treat the LLC differently than they do the corporation. And they don't make you name the stuff. So you've got a name, a mailing address, which can be a P.O. box, and a registered agent, which you should never be your own registered agent.
Why?
So Huh?
Why? Why?
Well,
I agree with you. Why? But why?
and I'll tell you why you should never be the registered agent. Because in order to be the registered agent, you have to give them an address where the sheriff or the marshal or a process server can come to serve you with paperwork. So it's going to be your home, your apartment, or your office. It can't be a P.O. box. It has to be a physical street address in the state of Georgia. So the detriment is this. If you say I'm the registered agent, but then you give them a bum address or you don't keep that address updated and someone comes to show up, then the stuff goes to the Secretary of State. And the Secretary of State accepts service as your proxy. So now you've gotten cute. They can't find me. Whoop, they just served the Secretary of State and a $12 million judgment just went against you, and you don't even know it. Now you don't even have time to prepare or do anything. And then one day you're going to be sitting around and they're going to get real busy when they get that $12 million judgment trying to track you down. And I cannot begin to tell you how many ex-FBI agents run private investigation firms here in Georgia that I use. I haven't missed yet in locating somebody. If they're in the state, I find them. If they're not in the state, we found them. I've not had a single person not be located. And I'm not going to tell you it's cheap because some of my clients have had to spend tens of thousands of dollars just on private investigators to track people down, but we find them. I just found a lady from 9 years ago. We just renewed her judgment. My client was like, I'm going to let go. I said, well, you know, he goes, just renew it. It's $80,000. By God, we found her working for DeKalb County, Georgia. I garnished her, and we're going to be getting about $1,000 a month. So every 6 months, I'm just going to refile the garnishment. So as long as she's working for the county, my client will get $1,000 a month to satisfy the $80,000 judgment for a driveway that was poured back in 2006. How's that? So tenacity pays off. The passage of time diminishes the likelihood of a creditor collecting against you. This lady probably never knew she had been sued because we took a default. No, she did know because I served her. She just didn't answer. But I got a default judgment against her. But she moved around a lot. I could never pin her down or find her. So my client finally spent the money on one of these ex-FBI guys to track her down, and we found her place of business, and we garnished it. And we're now starting to get paid, you know, almost 8 years later. So you never know.